On 9th December 2019, a bill was tabled at the Lok Sabha. It was an important bill with massive implications, as we will see. However, the 17th Lok Sabha took barely a day to pass it, with 311 votes supporting and 80 votes opposing. The Rajya Sabha and the President also took barely a day each to pass this bill. And so, like a magical wand, wave of a wand kind of a thing, the bill was transformed into the first act of independent India in which religion became a criterion for Indian citizenship. Before we begin to form opinions, I know we've already formed opinions, but before we begin to form opinions about this move and before we speak about the ramifications, we must look at the legislation itself. We cannot allow our ignorance to render us vulnerable to the machinations of others. I have been tasked with providing the bare bones information to three acronyms that suddenly erupted on the front pages of our newspapers and in our social media streams: CAA, NRC, and NPR. In order to distill this information, I wish to deal with each in turn, and I will attempt to give a framework for the necessity of each of these acronyms, some history where essential, and also describe where things currently stand. Those of you who know me to be quite opinionated, so you will appreciate how difficult it is for me to simply describe something without also giving my views. Of course, we will have sufficient time for that later. All of us will have the opportunity to air our views. So, what do these three acronyms mean? I don't know if you're able to see, I hope it is. Anyway, CAA stands for the Citizenship Amendment Act, NRC is the National Register of Citizens, and NPR is the National Population Register. So we will deal with these in that order itself. When you read the name of the act, you will see that the word amendment is in parentheses. And this indicates that this is not a new act, but an amendment to an existing act. This existing act, referred to within this Amendment Act as the Principal Act, is the Citizenship Act of 1955. Since the CAA of 2019 is an amendment, it does not invalidate the 1955 Act, but only introduces some modifications to the Principal Act as well as the amendments that have happened earlier. Now, this is not the first time the Principal Act has been modified. As I go through the history of the amendments, please pay close attention to the color and the legend that indicates how to interpret the color, because history is tied up with the party or parties that wielded power at the time of the amendments. The Citizenship Act was first modified in 1985 following the Assam Accord, and we will touch on this a little bit later. The following year, in 1986, the Act was modified to state that birth in India grants citizenship only if at least one parent is an Indian citizen. In 1992, this Act was again modified so that descent from an Indian mother also granted citizenship. Till that time, only descent from an Indian father was considered valid for people born outside India. No, that's for people who are born outside India, not those who are born inside India. Next, in 2004, the category of illegal migrant was introduced, and no such person was permitted to be granted citizenship. A year later, in 2005, the category of overseas citizen of India or OCI was introduced. 10 years later, in 2015, the Person of Indian Origin card, PIO card, was repealed and replaced with the OCI card. The final leg began in July 2016. The Citizenship Amendment Bill of 2016 was tabled in Lok Sabha at that time. This was passed by the lower house in January 2019. But then it got stalled in the Rajya Sabha, and then following the dissolution of the 16th Lok Sabha, the bill lapsed. Finally, as mentioned at the beginning, the bill was again tabled on 9th December 2019. It was passed by the Lok Sabha the next day, by the Rajya Sabha the day after that, by a slim margin of just 10 votes, and then finally received presidential assent on 12th December 2019. So we're talking about a period of just 3 days for both houses and the president to go through this. The question then arises, why is such an act necessary, or is it necessary? Now, India is a democratic country. Since the government is supposed to be of the people, by the people, and for the people, for those of you who have remembered that civics class we had whenever it was, it is crucial to know to whom the word people refers. In other words, in a democracy, it is crucial to know who a citizen is. Also important is to know how one can become a citizen and the conditions under which one can lose one's citizenship. In other words, while in a monarchy or an oligarchy, the people are actually irrelevant, and while in a totalitarian or authoritarian state they are simply overlooked, a democracy cannot function adequately without having a clear definition of what a citizen is. So, why is an amended act then necessary? This act has been amended multiple times, so why is an amended act necessary? We live in a world where the ground realities are constantly changing. What was beneficial yesterday may be detrimental today. Certain things that are in the Principal Act and that are addressed there may be obsolete today or irrelevant. And the Act then needs to be changed to reflect these new realities. In a democracy, continuous updating of existing legislature is needed because laws need to reflect current realities rather than venerate the ghosts of realities past. Hence, it is important for us to know how the Citizenship Act of 1955, and its subsequent amendments define a citizen of India first. The Government of India recognizes 5 broad ways in which a person may be granted Indian citizenship: birth, descent, registration, naturalization, and incorporation of territory. We will deal with the first 4, since the last one does not relate to peacetime. If India went to war and annexed some other territory, then that one comes into play. Right now, we will talk about the first 4. Anyone born, so this is direct from the Citizenship Act and various amendments. Yes, so I have not made any modification except for slight pagination, which formatting, I didn't like the formatting in the documents. Anyway, anyone born on or after 26th January 1950 and before 1st July 1987 is automatically a citizen of India. So, I think many of us qualify for that. So, yay and all that. Those of us who are those born on or after 1st July 1987, but before 3rd December 2004, are citizens of India if either parent was a citizen of India at the time when the child was born. Those born on or after 3rd December 2004 are citizens of India if at least one parent is a citizen of India at the time the child was born and neither parent is an illegal immigrant. The amended Act of 2004 is the first which mentions the category of illegal migrant and explicitly denies any such person the right to become an Indian citizen. We will look at the definition of illegal migrant shortly, so hold on to that. Citizenship by descent is for those born outside India. Those born on or after 26 January 1950 and before 10th December 1992 are citizens of India if their father was a citizen of India at the time when the child was born. Not the mother, the father had to be. If, however, the father was a citizen by descent, then the child had to be registered at an Indian consulate within a year, or the father should have been outside the country because he was employed by the government of India. Those born on or after 10th December 1992, but before 3rd December 2004, are citizens of India if either parent was a citizen of India at the time of the child's birth. So the mother was also added now in 1992. If, however, either parent was a citizen by descent, then the child had to be registered at an Indian consulate within a year, or either parent either parent should have been in the employ of the government of India. Those born on or after 3rd December 2004 are citizens of India if either parent was a citizen of India at the time of the child's birth, and if the child was registered at an Indian consulate within a year. So you can see now in 2004, the Amendment Act that came into force in 2004, while it introduces the idea of illegal migrants, now also does away with the separate category of children who are citizens, or children of citizens who were themselves citizens by descent. Okay, so that category is basically being is no longer in effect. All right, citizenship by registration. It's for persons of Indian origin. They may be of Indian descent, living in another country, or they may be minor children of Indian citizens who are born outside India and then either living in India or outside India. Or they could be foreign nationals who have married Indian citizens. So many categories like that. Instead of going that, it's just important to note here that this whole category for citizenship was added in the Amendment Act of 2004 and explicitly prohibits any illegal migrant from becoming an Indian citizen. Citizenship by naturalization is for foreign nationals who wish to relinquish their existing citizenship in favor of Indian citizenship. Such a person would be a resident of India, and the Amendment Act of 2004 then inserts the condition prohibiting any illegal migrant from becoming an Indian citizen. So we can see from 2004, no illegal migrant is allowed to be a citizen of India. Now, as mentioned earlier, this act was the first to make special mention of illegal migrants, so it's important for us to understand what this term means. In brief, an illegal migrant is one who has entered India without valid travel documents. Travel documents could be the combination of a valid passport and a visa, or you could have other travel documents depending on the country that you are in, but you need to have all the travel documents that you need and to come into India. Also, if you have overstayed your welcome, that means while you're living in India, while you're residing here, if either your passport or your visa has lapsed, then you're automatically an illegal migrant. So, if any of you have come here, please check your passports and visas and make sure that you're legal and all that. Yeah. However, the Amendment Act of 2019 provides an exception to the definition of illegal migrant. The exception is then based on the 1920 Passport Act, which grants the central government of India the authority to make any exceptions to who is allowed to be inside India. Okay, so the Passport Act tells you need a valid passport, you need a visa to come into India. And then but then it says that the government of India can give exceptions. So this is now on the basis of the 1920 Act, which is an interesting thing. I shouldn't be giving my opinions. Sorry. Okay, this is just bare bones facts. Okay, sorry. The exceptions are made as follows. People coming to India from Afghanistan, Bangladesh, or Pakistan on or before 31st December 2014 are not considered illegal migrants if they are Hindu, Sikh, Buddhist, Jain, Parsi, or Christian. As mentioned before, this is the first time citizenship in India has been defined with religion being a criterion. Okay. That brings us to the National Register of Citizens. I could say more, of course I could say more, but that would become lines of opinion and all that, and I've not been allowed to do that, so we shall move on to National Register of Citizens. So what is this register? Simply put, it is just an official record of Indian citizens. It was first prepared during the census of 1951. Oh yeah, that was the last time it was prepared also. So, yeah, the current register has data that is almost 70 years old. Most of us were not even born then. Those of us who were born then were at that time not eligible to vote. So there you go. Yeah, so it has basically no person in that register who right now is alive and eligible to vote. Yeah, pretty much no one's there. Yeah, unless someone's like 80 years and older or something, they may qualify. I don't know. Anyway, did this move on? No, this. Okay. Before we move on, we need to ask a question: why is such a register needed? So, every nation grants its citizens some rights that it does not grant others. The right to vote, the right to maybe education or to health care, or right to purchase property or something like that. So every nation gives its citizens some benefits. There is something that you gain by being a citizen. So it is important that we know who has a say then in policy matters, the citizen, and who does not, the non-citizen. In plain words, the NRC should have data about which people have a say in the direction that a nation takes. So that's what the purpose of the NRC is. Now, I mentioned that the NRC was produced only once in 1951, and of course, as usual, there is an exception. The exception is Assam. From 1948 to 1971, Assam experienced a huge influx of illegal migrants from the erstwhile East Pakistan. This continued even after East Pakistan became Bangladesh. And many of these illegal migrants managed to get their names onto the voters' lists. Suddenly, the Assamese people faced a situation where those who had illegally gained entrance into the country and then illegally got their names onto the voters' list suddenly had the ability to vote. And they were numerous enough that it affected the outcomes of the elections. In other words, the illegal migrants had become a vote bank, and the politicians were eager to please them. A student-led protest lasting about 6 years broke out in 1979, and it ended in 1985 with the Assam Accord, which granted citizenship to anyone who came to India from Bangladesh prior to 1st January 1966. The waters, of course, were muddied by the Illegal Migrants Act of 1983, which stipulated that date to be 24th March 1971. So you have an earlier act, that is the Illegal Migrants Act of 1983, that had then not been repealed, and it has a later date, while the later act, which is the amendment of 1985, has an earlier date. So you can see the nice confusion that we have. The Illegal Migrants Act was put into place supposedly to assist in identifying illegal migrants, but in actuality made it more difficult to make such identification because it made proving citizenship a little too easy. And so it was finally repealed in 2005. How did it last that long? Anyway, sorry, opinions coming on. Okay. In 2013, 2013, the Assam Public Works and Assam Sanmalita Mahasangha and ORS. I have no idea how to pronounce that. Anyway, they filed a writ petition at the Supreme Court of India. A writ is simply a formal written order issued by a court. Could be a warrant, an order for someone to do something, or a directive or something. This is the principle you need to follow, something like that. The writ orders the recipient to perform or cease to perform some action that is mentioned in the writ. A writ petition is a written plea to the court to issue the writ that is sought by the petitioner. So far so good? Okay? Legal terminology and all that? Okay. The writ we are concerned with had the goal of deleting the names of illegal migrants from the voters list. Not throwing them out, just getting them off the voters list. Yeah? In 2015 then, the NRC was updated in Assam. The reasons for the update, of course, should be quite clear by now. In a democracy, only adult citizens should have the right to vote, not everyone else. However, this vote now, the voters list at that time had the names of many who had entered Assam illegally and then somehow managed to get their names onto the voters list. So the list had to be cleaned up so that it would have only those names, of people who were legal citizens of India. So that brings me to the National Population Register. Once again, I have much to say about this. We will say it in our group discussion because this is outside my jurisdiction today. So we move to the National Population Register. Again, what in the world is this register? The NPR is the official record of those who normally reside in India. It is normally updated as part of our census. And if the past progression is any indication, the next census and consequent update to the NPR is due in 2021. Once again, we need to ask, is this thing necessary? Or why is it necessary? Now, a government is elected only by adult citizens, but a nation needs to be able to provide for all who live within its borders. Food, water, energy, employment, housing, education, healthcare. These are all things that we expect a nation to be providing for its populace. Maybe we should be expecting the nation to be providing those things for the populace. Anyway, that's opinion. Hence, it is important to know how large the population is as well as the demographics, and therefore the need for a population register. So that brings me to the end of my summary of these three acronyms that suddenly occupy our thoughts and give rise to the angst in many hearts. As we have seen from portions regarding where I had the framework of each of them, these are important aspects of policy. These are not things that shouldn't be done just as a blanket thing, because they enable us to answer questions like who has a say in the direction that a nation takes, and how do we define such people, and are those who pay taxes responsible for the welfare of those who entered illegally? These are important questions that we need to answer, and these policies could help us answer that. However, the framework is not the only thing that matters. There are issues of implementation and intentionality. Unfortunately, it is not my task to speak on those. And so, I leave you with two quotes. The first is by Elie Wiesel. We must take sides. Neutrality helps the oppressor, never the victim. Silence encourages the tormentor, never the tormented. And the second by Margaret Mead. Never believe that a few caring people can't change the world, for indeed that's all who ever have. Thank you.